All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in our cause number 1CA UB220017, Aguilar versus the Arizona Department of Economic Security. And counsel, we have read your briefs in this matter. We've conferenced this case this morning in conference. Both sides have 20 minutes to present argument. The appellants are reminded that if they want to reserve time, they need to keep track of that on their own. Would you, as you approach the podium, if you would please state your name and the person for whom you represent, and with that, we'll hear from the appellant.
Good morning. I'm Yvonne Tyndall on behalf of Appellant Tia Aguilar. Chris Banaszewski is also here today. We're here on an unemployment benefit case. The main issue is whether the appeals board properly determined Ms. Aguilar's settlement offer was a threat and therefore she was terminated for misconduct. Case law says that whether the employer met its burden of proving that the employee's conduct was disqualifying misconduct is a question of law freely reviewable by the court. Here, the appeals board's decision relied on the terms of the settlement offer. So now the court can look at that settlement offer once again and determine whether it was actually a threat constituting misconduct. Ms. Aguilar's employment was terminated after she presented a settlement offer to her employer. The record demonstrates that her communication was indeed just that, a settlement offer, which is not disqualifying misconduct under Arizona law. Instead, the employer took this statement, quote, "Tia will create a dialogue about leaving that does not harm the company or her reputation," and turned it on its head, when it was actually a settlement term, a non-disparagement term that positively reflected on both parties. The employer assumed that Ms. Aguilar was saying something else and presenting an unspoken option about what she would do if the settlement weren't accepted. However, Ms. Aguilar never said, "Accept this offer or else." The employer.
Well, she did say it was a non-negotiable settlement offer, didn't she?
I think she did testify that, but the terms of the offer didn't say this is non-negotiable. And also the recording of her meeting, she read from this settlement offer verbatim. So maybe after the fact she looked back and said it wasn't negotiable as in I wanted to separate from employment. But I think the terms.
Well, what does non-negotiable mean to you? It means to me it's like this, take it or leave it.
I agree that's what that means, but I think we should focus on the terms of the settlement offer itself and also the recording of the meeting with the employer. I don't think in that recording she said this is non-negotiable. So relying on the terms of the offer, I think, is okay.
But what if she did say that? Just assume, does that make it a threat?
I don't think that makes it a threat because the language of the term that I think was taken as the threat, she will create a dialogue about leaving that does not harm the company or her reputation, isn't saying if you don't accept this as is, then I will go out and besmirch your name. It operated as a standard non-disparagement term.
Is that the only part of the offer that could be considered a threat?
Are you?
Well, what about like the $1,000 fine per day, or some of the other, I mean, seemingly sort of draconian or somewhat outlandish requests that were made by the claimant, you know, to have a $1,000 fine if the Martinez stepped foot into the room where Ms. Aguilar was working.
Sure. Those demands, and the appeals board kind of referred to those as rather a list of demands more than a settlement offer. I think the record shows that it wasn't really a list of demands. It was presented as terms for separation from employment. And employer didn't have to accept those terms. Regardless of how unsophisticated those terms were, it was still a settlement offer. And the fact is that Ms. Aguilar put this offer together herself. And so perhaps because it wasn't as sophisticated as what an attorney may have put together, that isn't something that should be held against her.
So in looking to decide, because as you've stated, it's de novo review on whether this constitutes a threat. So what would you advise us where to look for us to determine what constitutes a threat? What kind of case law, what kind of statute, because there doesn't appear to be any guidance or much guidance in the regs
Right.
of DES.
Right. Well, if we turn to the case law that the department cited, I think that those are distinguishable and help us see what is a threat to see here that it wasn't a threat. So first, in Anderson versus ADES, the position is that based on that case, here Aguilar insinuated that she would threaten the employer. But there, the claimant actually wrote a memo criticizing the employer and sent it to internal personnel as well as outside contractors. And the court determined there that that was disloyalty. Here, there's nothing like that, where Aguilar actually tarnished the employer's name. There's no evidence that she shared the settlement offer with anyone else or criticized the employer. So that case is distinguishable. Also, if we look to another case that the department cited, a Pennsylvania case, Groskinski versus Unemployment Board, it gives more guidance too. There, the claimant was discharged for telling fellow salesmen, I'm going to tell the customers to take their business elsewhere. That case, I think, actually supports our position because the settlement offer can't be taken for anything else or it's not the same thing. We don't have anything like that here. There, if you look at the actual language of what the employee used, I'm going to tell customers to take their business elsewhere. And the court reasoned, it's a threat if you say what you're threatening to do. Versus here, Aguilar said, Tia will create a dialogue about leaving that does not harm the company or her reputation. Those are completely different. And like I've said, her testimony and the recording of the meeting with the employer all support that that was all that was said.
What was she settling?
She was settling, she reported sexual harassment to her supervisor or co-owner of the company, and she experienced retaliation from the other co-owner for reporting that sexual harassment. And so because she had experienced a few weeks of that retaliation, which made it very difficult for her to do her job, and she testified, I felt like I was being pushed out of this job, she got to a point where the employer wasn't doing anything about it, and so she had to do something. So that's what she was trying to settle.
And what was the employer getting in return?
I guess in return, the employer was parting ways with her, and also that she was going to train her replacement. She was going to work on Christmas and New Year's. She was going to be on call. So she was going to transition out of her role, and she wasn't going to leave them high and dry, along with this non-disparagement term.
So I think the department argues that the offer, the settlement offer, it completely lacked any consideration. What's the relevance of whether or not it did have consideration? I mean, let's assume there was none. Let's assume there was none. How does that impact the threat analysis?
I guess that will go to whether she said, these are my terms, and I'm walking away and going to, under these terms. I have to think about that.
It doesn't matter, does it? Because the employer could get consideration in the form of, I'm not going to go out in public and disparage you. That would be consideration, but it wouldn't mean it's not a threat.
Sure. If that were the consideration of, I'm not going to go out and disparage you, I think,
And I'm not saying it is, I'm just saying that that's an example I can think of quickly where there is consideration, but that doesn't mean it's not a threat.
sure. I think that going off of that, the non-disparagement term here, if affirming the appeals board's decision that this non-disparagement term was actually a threat, it would in turn have the effect of having any employee who wants to separate from employment with their employer, and they offer a settlement offer, which includes a non-disparagement agreement, that would right away be a threat, and that employee could be terminated for misconduct and not eligible for benefits. And that would be kind of a tricky precedent to set. So I think that's why the non-disparagement isn't a threat. And going off of that, non-disparagement terms are common terms in settlement agreements, and it's something that you would see often. So here it shouldn't be treated any differently from other settlement offers. They're not considered threats in other settlement offers. Also, the employer...
What role, if any, does the employer's reaction on the recording to her offer play in our analysis?
Their reaction?
Sure. I mean, I've listened to the recording.
Sure.
The employer doesn't react like someone that's just been threatened at the
Sure.
end of the meeting.
Right. I think that shows that their subjective interpretation of this was a threat, we felt extorted, she was demanding money, was after the fact, and it wasn't necessarily based in the evidence and the terms of the settlement offer and their conversation with her.
I guess what role does intent play in terms of the person making the offer? Does there need to be a subjective intent to threat, or do we just look at it objectively? Or does intent not matter?
On the part of Ms. Aguilar?
Correct.
Oh, I think that matters, because the combination of the plain language of the settlement offer she put together and then her delivery in the meeting together show that she wasn't saying or providing it in some sort of tone of, this is it, I'm threatening you, or else, and you'll be sorry if you don't accept this. There's nothing like that, and so I think that lets the court know that there was no intent to threaten them.
So let's flip that a little bit. So as the receiver, the company is the employee, the employer.
Yeah.
How should we be viewing that? Is that from a reasonable person standard? Like a reasonable person in those shoes hearing those statements or receiving that offer is an objective or subjective test? I mean, in other words, do we go all in on what the employer actually thought, and they testified? Yeah, we thought this was extortion. This was terrible. They testified to those events. Is that controlling, or is it an objective test? And do you have any authority that goes one way or the other, like how we should be evaluating that?
I think it's an objective test, and perhaps the authority would be just your standards of review, a reasonable interpretation of the facts.
And isn't it an objective test in terms of the intent of the persons allegedly conveying the threat? In terms of their intent?
I think that makes sense. In order to have fairness towards the employee. The issue is...
It seems like it would be harder to prove subjective intent of a threat.
Sure. And as seen here, it's like a weighing, but the employees, if you look just to the straight evidence of the settlement offer and her recording, going with the objective test makes the most sense. Also, this isn't an issue about whether or not they wrongfully terminated her. Obviously, they didn't like that she made the settlement offer and they let her go. That's okay, and we're not challenging that. The issue is that now they've terminated her and for misconduct, and she's at this time not eligible for benefits. That isn't what the law says. It shouldn't be that the employee tries to separate from employment on good terms, and then that's totally flipped around and the employer says, I felt threatened. There was a non-disparagement term that to me was a threat, and she demanded all to be paid and before separating.
So this is the odd case where we have the document and we have the recording. We can be in the room with.
Sure.
I mean, we can't see their faces, but we can hear what's being said. What, if any, because of that, what, if any, role does later testimony from either the employer or the employee, what role does that play in terms of our appellate review? Or is that irrelevant because we have the recording and we have the document?
I suppose to the extent that the testimony is inconsistent with the document and the meeting, then the weight of the testimony may be less.
Is there anything for us to defer to in terms of what the board did here, given that we have the recording and we have the settlement offer?
To defer to
the board.
The board? I don't think you have to necessarily defer to the board, because you can review the settlement offer and the recording as they are, and you can reverse the board based on that.
Well, we would be reversing the board for their legal conclusions, not for their findings of fact, wouldn't we?
You would be reversing their legal conclusions, but I think you could also conclude that their interpretation of the facts wasn't reasonable to reach that conclusion.
Do we need to, I mean, to me, it seems like we have to determine legally what is a threat as it relates to this employment area. And that is a legal determination that we would not defer to the board.
Right.
So then it's a mixed question of law and fact.
Yeah.
Which we review de novo.
Right. Unless there are further questions, I'll reserve.
I just have one, sorry.
Sure.
If the ultimate question is whether she was terminated because of misconduct, can we analyze whether there was insubordination, even if there was not a threat? Or is it too late for that?
I think it's too late. I will reserve the remainder of my time. Thank you.
All right, thank you, counsel. We'll now hear from Appali.
Good morning, Your Honors. May it please the Court, my name is Jennifer Bloom, and I'm here today on behalf of the Arizona Department of Economic Security.
Ms. Bloom, before you get started, inquiring minds want to know, why are the employers never here? Not that you don't do a great job. It just seems odd that we have two parties that are disputing a fact and we have the person representing the arbiter that is standing in front of us.
Well, Your Honor, I am not the attorney for the employer, and I'm not the employer themselves, so I don't feel that I have any basis to represent why they chose not to be here today.
Did they have the opportunity? I guess that's my question. Did they have the opportunity and they just chose not to be here, or?
It's my understanding that they were sent the notice of oral argument from this court. I'm not 100% sure on that. I can represent accurately that I copied them on all of my filings.
And not to belabor this, but so when an employer doesn't show up, doesn't file a brief, normally we would hold that as a concession of error against that party. Why shouldn't we do that in this case?
Well, in this case, we do have the department has shown up to defend its prior decision. Okay. And so at least one party is here defending it. And I believe that when you have multiple parties who are aligned in their positions, if one of those parties showed up, that it would be inappropriate to treat that as concession of error.
All right, thank you. Sorry for the interruption.
Not at all, Your Honor. So Ms. Aguilar keeps referring to this as a settlement offer. And she says that the intent behind this was to settle her claims of sexual harassment and retaliation. The thing that's missing from this so-called settlement offer that I think is really telling here is a provision that says, okay, I release any claims of sexual harassment and retaliation. So really, I don't know how we can call something a settlement offer when it literally does not say, I am agreeing to release these claims that I might have against you. And another thing that I think is really significant is
Isn't that implicit within the document itself? I mean, when I read it, I'm thinking, well, this is resolving her any and all claims that she may bring against the company.
Well, it doesn't say that she is resolving any and all claims against the company.
That's why I said, is it implicit within the document?
I don't believe that that is implicit. I think that is a term that if you're going to have a settlement agreement needs to be expressly included. And Ms. Aguilar claims that she was an unsophisticated party drafting this, but actually her own testimony was that she consulted an attorney when she came to the company with this offer.
Doesn't that make the document less threatening, though, if it referred to potential legal claims and said, I will release those claims? I'm not sure you wouldn't be here standing here saying that that was an implicit threat of bringing a legal action later if you don't accept these terms.
I think the difference there is between whether this is a good faith offer to settle claims that she believes she has against the employer or a list of demands, essentially. And I think it's really crucial that she's not actually saying, I'm going to release any claims that I might have. The other thing that...
And when we determine whether it was good faith or not, is that a subjective standard or an objective standard?
I believe there's two parts to the standard of whether or not something is a threat. It's a combined objective and subjective standard. It has to be objectively, a reasonable person could perceive it as a threat. And I think there is also a subjective element that the person hearing it did in fact perceive it as a threat. So,
What about the person making it?
I don't think that, as Your Honor commented, the subjective intent of the person making it is very difficult to discern. So I think we look to the surrounding circumstances to determine whether or not it was intended as a threat.
Right, but the fact it's difficult to discern may be a good thing because maybe we want to encourage folks to try to resolve their differences in the employment context.
Certainly.
And we want to protect speech.
And since you brought that up, actually, I think that's a really good point that the employer here absolutely did try to resolve their differences. They contacted Ms. Aguilar multiple times. They asked her to come in for a meeting. They told her what they were doing to resolve the situation. She didn't respond to any of those attempts. She said she was too uncomfortable to come into a meeting. She didn't respond to emails. She never told them, I don't think this is enough. I want you to do something else. She never took up.
What they did do is when she made this demand or this threat or whatever it was, there was no negotiation, no attempt at negotiation. There was a simply, you're fired, right?
Respectfully, Your Honor, Ms. Aguilar didn't give them the opportunity to negotiate. And in fact, it was her own, I believe the recording actually does contain her saying that it's non-negotiable. I don't have it with me here today, but I believe that is correct. And then her own testimony at the hearing, which I do have the transcript.
Yes. Lawyers say all the time, it's non-negotiable, and then they negotiate. So is that really a bright line that we're drawing here?
Well, we have her statement that this is non-negotiable and also that it expires the following business day. We have her saying...
But she didn't say that. On the recording, she says, I'd like a response by 7 a.m. on Monday because that's when I'm scheduled to come in. But if you need more time, I will give it to you. I'm just going to work from home until I do get a response.
That's true. But as far as whether or not the employer could alter the terms of this agreement, I think it was made very clear that she wasn't open to that because she came into her position at the meeting was, I'm going to read the statement and then I'm going to leave. We're not going to have a discussion. We're not going to have a dialogue. And she'd had 3 weeks, sorry, not 3 weeks. She'd had from December 2nd to December 10th to enter negotiations, to say, I know you said you're sending Mr. Martinez to these trainings, and I don't think that's enough. I want you to do something more. I want you to, any of the things that she listed, she could have said then, and maybe then they could have come to a good compromise that would have allowed her to continue her employment or to leave her employment on good terms, whatever the parties ended up agreeing should happen. But Ms. Aguilar, instead of taking any of those multiple opportunities to let her employer know no, I don't think you've done enough, showed up with a list of frankly exorbitant demands, a year's salary in a lump sum untaxable payment, $1,000 if the co-owner of the company entered the room where she worked, and I believe the testimony was that this was a small company and that keeping somebody not out of the room where she worked simply wasn't feasible for them. That she gets guaranteed employment for 30 days where she can't be fired for any reason, and then another 60 days of employment at her sole election, only if she chooses to.
But admittedly, the demands were unreasonable. But just because you make an opening salvo in trying to resolve a dispute that's unreasonable, how is that good cause for firing?
I think it's clear again from the record that this wasn't an opening salvo. She came to the employer and she said, this is it. This is this is what I want, take it or leave it. And her own testimony again was, this is non-negotiable.
But even if it is, how does that change? Well, and I think we need to drill down a little bit more on what is a threat. So how does that constitute a threat under what authority? Are we looking to criminal law? Are we looking to Black's Law Dictionary? What advice? And I noticed you cited the Pennsylvania case, which then led me in research to look at other cases, the unemployment benefits cases. They almost all either talk about specific sabotage to the employer's business, or they're threats of physical harm. Like one coworker slapping another one, threatening to hit somebody, those types of almost exclusively focused on, or many of them focused on the physical injury component. How is this even close to those kind of cases?
Yes, Your Honor, I admit I found those same cases when I was conducting my research. But one, I would say that I think this is very similar to both the Anderson and the Groskinski cases, and the attempt to distinguish them based on the fact that she didn't actually follow through on her threat doesn't mean that it's not a threat. And the other thing I would say is that we can also look disloyalty. Disloyalty was also cited.
Was that found by the board?
I believe the board cited to the regulations governing disloyalty, and I think that might even have been underlined. If I can check if you would like.
No, I mean, I believe you're correct, but does that mean the board? But the board didn't discuss it. The board didn't apply the facts to the law. How do we just presume that the board found that?
In the board's decision, when it recites, it makes a habit of when it's reciting the law that it does underline the portions that it finds to be particularly relevant. And I believe that it did that here.
Yeah. I think you're correct that the word disloyal was, but the board also cited that behaving in a manner not in the employer's interest, I believe. But the board didn't, I don't know if that was underlined. So is that, it seems like you're suggesting that we should essentially affirm for any reason that supports the board's decision? Is that a principle that applies in unemployment benefits cases?
Your Honor, I honestly couldn't say one way or the other on that. I know it is a general principle in appellate law, but I'm not aware of any case that specifically applies it to appeals from unemployment benefits.
Okay, that's fair.
The disloyalty provision says, disloyalty is misconduct when manifested by acts or omissions by a worker which establish a breach of the obligations owed his employer. What did a demand letter suddenly becomes a breach of or an omission owed to an employer to say, you're doing something wrong and this is how I want to settle my claim?
The obligation owed to the employer in this case was the obligation to not damage the employer's reputation. I think that's very similar to the Anderson case.
But she didn't do anything. I mean, this is all just in a letter between her and the owner of the employer, right? So how did that damage the employer's reputation?
I think I'm not sure that it's logical to make a distinction between an employee is allowed to threaten to do this, but not to actually do it. If the action is misconduct, then the threat to perform the action should
Well, she'd have
also-
marched in and said, I've consulted a lawyer and I'm going to bring an action for retaliation against you. Then the employer could have fired her. So we're going to add more retaliation to the retaliation they already did.
Well, respectfully, Your Honor, that's not what happened.
Admittedly so, but I'm just asking you a hypothetical.
Hypothetically, if she had walked in and said, I plan to sue you for sexual harassment retaliation, and they had fired her, then yes, I do believe that that would be actionable under Title VII.
And she would have been entitled for unemployment benefits.
Yes, I think that would be correct.
So what was the or else here?
I'm sorry.
I think you maybe have mentioned it, but what is the or else here? In terms of, I'm giving you these terms, there has to be an or else for it to be a threat. In your view, what is the or else that Ms. Aguilar was communicating to her employer?
The or else was that she was going to damage the reputation of the company, and that's what the employer
And
specifically...
where is that manifested in the record? Because I didn't hear it in the recording. Is it in the document somewhere?
I think it's implicit from the circumstances of how this offer was presented, what the offer itself was, and the fact that what she's offering is, if we agree to this, I won't say bad things about the company.
And what about how the offer was presented had that or else in it?
The fact that she presented it, showed up to the meeting and said, I'm reading the statement, and then I'm leaving, it's not negotiable, and all of those circumstances contribute to the understanding that the employer reasonably had and testified that this was their understanding, that it was an or else situation. And the employer testified that as a small business, their reputation was really crucial to them, and that an employee damaging it could be harmful to their business.
She ended the meeting saying, I love this company and I don't want to do any harm to it or myself. So what role does that play in our analysis?
I think that what she said, and this actually occurred to me when you were asking Ms. Aguilar about the employer's response, is what's said while you're still in the company of the other party doesn't necessarily reflect how you actually feel about the circumstances. And these were people that she had worked with and had a relationship with. And so, yes, of course, she, while in person, wanted to have a good personal relationship. But that doesn't...
I guess I just don't understand how, as a court, we're supposed to look behind her express statements based on her relationship with her employer to determine whether she actually meant something else than what she actually said. How do we do that?
The other thing, I think, is when she can say, well, I don't want to hurt this company, but that doesn't mean I'm not going to hurt this company. I think you can understand that as, I want you to take this settlement offer, or so-called settlement offer, and then I won't have to hurt this company.
And what part of the document itself was the manifestation of the or else?
So again, I absolutely acknowledge that the letter does not explicitly say or else.
Sure, I don't think it has to, but where generally was the threat made in the actual document, the settlement offer?
When we look at that, really the only thing that was being offered here was, I'm not going to disparage the company.
No, she says I'm going to work for 90 days and train whoever needs to be trained.
She says that she's going to she says she's going to work for 30 days, but she also says, I can't be fired for any reason during that 30 days. And then she says, and if I want, just me, not you, you don't get a choice in this, I can keep working for another 60 days, and it will be from home. So just from all of the circumstances here, I think the or else is very clearly implicit, and the employer testified that it was their understanding that this was an or else situation.
I'd like to talk about retaliation for a minute. Would you agree with me that the record confirms that Ms. Aguilar, there was retaliation against her, at least one instance, when Mr. Martinez confronted her about the sexual harassment report?
Yes, Your Honor.
That was retaliation. How did the board account for that in its decision when it found that there was a threat without provocation? Did the board specifically take that on and say, we recognize that Ms. Aguilar, there was retaliation against her, but that doesn't matter because it was insignificant? I didn't recall any such finding, so I'm wondering how we could say that the board accurately looked at that component to make that finding without provocation.
To the best of my recollection, the board did not specifically use the word retaliation, but it did acknowledge that the December 2nd phone call had happened, and then found that when Ms. Aguilar reported it to the company's HR, that company's HR then acted on that right away. They went and took restorative measures. They called meetings, they talked to their attorney, and they then said, okay, we're going to require Mr. Martinez to go to training so that he understands that this behavior was inappropriate and to ensure that it's not going to happen
Do we
again.
know anything about what kind of training he attended,
Management training and anger management training.
but not sexual harassment training?
Although it's not explicit, I would assume that any kind of management training that one would be sent to would include training on sexual harassment.
I would hope so.
And again, Ms. Aguilar was told that this is what the company was doing, and she had every opportunity to say, actually, this isn't enough. I want you to have somebody else in the room with me if he's going to be in the room with me. I want to make sure you limit how much I interact with him. I want him to do...
Is that unreasonable? I mean, from a reasonable person standard, is that unreasonable that you've witnessed sexual harassment and you don't want it to occur again, and so you lay down some demands?
That in itself is not unreasonable. And I think we wouldn't be here today if Ms. Aguilar had said, I don't think you're doing enough, and here's what I want you to do differently, and the parties could have continued to talk and possibly come to a settlement, or an agreement that would have worked for both parties. But that's not what we have here. I see my time is almost up. If your honors have any more questions, I'd be happy to answer. Thank you very much.
All right, thank you, Ms. Bloom. Counsel, any final word?
The record does not support the appeals board's decision that Ms. Aguilar was fired for disqualifying misconduct. And this boils down to a simple issue, whether her communication was a settlement offer, and it was, and that was not misconduct. And unless the court has any further questions, I have nothing further.
No, thank you.
Thank you.
The matter is deemed submitted. We'll issue a decision in due course. The court is in recess.